There are tons of business podcasts to choose from, but only one has the stamp of approval. Kristen Stampini is South Florida's leading real estate entrepreneur and your trusted source for everything real estate.
I would like to welcome our listeners and thank you for joining us today for an episode of our podcast, The Stamp of Approval. I'm Kristen Stampini, co-founder of the Stampini team with RE/MAX in Boca Raton, Florida. I'm also a certified real estate coach for Craig Proctor Systems and the owner of Global Virtual Assistants. The Stamp of Approval podcast was launched to share and educate other realtors, consumers, and other business owners across North America by sharing value and content to our listeners each and every episode. I share my personal experiences, my triumphs and my failures, and strength throughout my entire life in hopes of my audience being able to expand their knowledge on everything in real estate and business and sales and actually mindset oriented. We launched also just recently Stamp TV on YouTube. Gotten great feedback on it. Recommend you go on there, and it's where I share weekly real estate tips for everybody out there, buyers, sellers, real estate agents. So if you like our podcast, all we do is we just ask that you share it to people that you think can benefit from it as well. So today we have back Erik Eastham with the Eastham Law Offices. You know, the Eastham Law Offices is a family business practicing for over 35 years and specializing in estate planning, probate, asset protection, trust and estate administration, business organization, real estate, and contract transactional law. Attorney Eastham prides himself in creative estate planning and business organization, often saving, winning, and protecting his clients and their assets while maintaining a personal relationship with them. Eastham also believes in educating his clients and the surrounding community on the importance of proper planning. He is actually one of our attorneys as well. So welcome, Erik.
Hey, how are you?
Great. Nice to have you back.
Thank you.
So today we're going to be talking about selling properties in probate. Can you sell a house without going through probate?
Well, are you saying, well, yes, you can, but if the person who owns the house is dead, then no.
Okay. So talk about what probate is.
So probate, in the simplest form, is simply moving an asset from a deceased person to a living person. It's the court process that must take place to move an asset from a deceased person to a living person. It's very long. The fastest it usually goes is about 8 months to a year, and it's very expensive. In Florida, we have our fees put right into the statute, and the statute, there's more to it, but the gist of it is that attorneys get 3% of the gross estate.
So how do I not have to go through probate?
You avoid probate by there's lots of ways you can avoid it when we're talking about your home or a piece of real estate. The best way, in my professional opinion, is you want to leave that property in a trust. If it's an investment property, it would already be in another type of entity like an LLC or a different type of trust. It doesn't have to be in your revocable trust. And you can have your business owners, typically your children who are owners with you, they can inherit the business. Other ways that people do avoid it without a trust is you'll hear things like a ladybird deed or a life estate deed or things of that nature. But what we recommend to most clients is leave it in the trust. You're not going to have to answer to anybody. You're not going to need the kids to sign off on the deed if you want to move. It's probably the best way to go, and it'll protect you while you're alive, whereas a deed, it's not really protecting you while you're alive. And I'm talking about guardianships. So
if I have a home that I'm living in, and I die, and it's just set up, I have no wills, no trust, no nothing. Is that when it goes into probate?
Yes, that's called ownership in fee simple. That means that Kristen Stampini is the owner of the home. She's passed away. While she was alive, she was the only person who had the authority to sign the deed to sell it. So who can sell it now? Well, the only way you're going to find out is by opening up a probate, which is going to be somebody being appointed by a judge to be your personal representative. Other states call them executors or executrix. We call them personal representatives.
So why wouldn't you just give it to my kids?
You mean in a deed?
Yeah, I mean just...
So you can so if you just say, there's lots of ways you can do a deed, but if you want to say on the deed, Kristen and her kids, well, you've already split up the ownership in the property. You probably want to take full homestead exemption, and you technically don't really qualify now, so that's not a good idea. If you want to say Kristen to life, remainder to children, you've created a life estate in yourself, but no one's going to buy a life estate from you because it's still based on your life. I'm not going to buy your house and then you pass away the next day and I no longer own it. So in that situation, you would need to have your children sign off on that deed too. And we see families fall apart, and we see children hold mom and dad at ransom for their signature and say, Mom, Dad.
Oh, I see it.
You've got the life estate, I got the remainder. If you're looking to sell,
I already
you gotta pay me to get my signature on that deed.
I see it all the time. It's crazy. And so if I just have a home and I don't have a will or a trust, it has to go through probate.
Technically, yeah.
Okay. And why does it take 8 months? That's absolutely crazy.
It takes a long time because the judge is not simply concerned, the court is not simply concerned with making sure that your heirs receive what is due to them. They're also making sure that you don't owe money to anybody. Now, homes are special in Florida. We have homestead protections, so they can move a little bit faster. But if it's not a home, if it's an investment property, the judge, again, is not just interested in who's supposed to get it in your eyes. Do you owe money to anybody? And do they have a claim against this property? Or would they have a claim against you? That's called a creditor. And as much as some people say, I don't have any creditors, everybody has a creditor because everybody owes Florida Power and Light. That's the utility company here in Florida. Everybody owes to keep the lights on for the past month. Everybody's been using water. People have bills that they just pay off monthly. And you still got to pay those. And there's also the IRS that we got to think about as well.
So can I just pay to speed that up? Because I think 8 months is absolutely crazy, right?
So as far as getting the property sold, it's not going to take that long to get the property sold. The 8 to 12 months is how long is the entire process going to take. That's somebody getting appointed, going through the entire administration, and then seeking a discharge, which everybody's encouraged to do. You don't want to be held on the hook. You don't want to be liable for things that showed up later. So when you're finished with the business, you want the judge to say, you're no longer responsible for this estate. You're going to get discharged. And that's the end of it. So,
and you said it's 3%?
3% is the attorney fee on the gross estate. So if you think about it, the average home down here in South Florida, I'd say, you know better than me, but I'd say about $300,000 to $350,000 is average. Right. So we're saying just to move this house, we're going to have to pay an attorney $9,000 to $12,000 just to get the house to the kid that I wanted it to go to. Whereas if it was held in a trust for a couple grand, they don't even need a lawyer. They get to skip probate altogether.
So the way that should be set up is to pay the couple grand to put it in a trust. Then you don't even ever have to go through probate if you die.
If everything you own is in your revocable trust, no, there is no probate.
Wow. Okay. And why don't people do it?
Why don't people put their things in a trust? The biggest reason that I see or I hear is they don't think they're going to die yet. People say, oh, I'm not old enough for that. Yet I tell people, if you think back to the time you were probably 20 years old, that's probably when you probably experienced your first didn't see it coming death that you knew, a friend or a family member or somebody. And the older you get, I'd say by the time you're 35, you couldn't even count how many that had happened to. And they all didn't think it was going to happen to them either. So it's that. And then the other thing is they think it's too expensive. They think that that's for very, very wealthy people. And I've said it before, the very, very, very wealthy ones, they're the ones who can afford no plan because of all the money it's going to cost them. They're still going to have a lot of money. It's the ones who have a lot to lose that need the plan.
So when you talk about a couple $1,000s, you're talking about a one-time fee.
A one-time fee, yeah.
So you got to do it at some point. Mm-hmm. So why wouldn't you do it then, right?
Because they're procrastinators. They don't want to think about it.
Do they even know, though, that they have to do it? A
lot of people don't think about it. Or they think, or if, like, for example, if I've got a couple, they come in and they say, we got a baby, we bought life insurance to take care of the baby. That should be enough, right? Well, no. I mean, what's the plan for the life insurance? And the younger you are, the more you usually buy. So let's say they got $1 million. Well, what are you going to do with the $1 million? What's it for? What is it used for? Who's in charge of the $1 million? Because it's not going to be a baby. The life insurance company is not cutting a check to a 10-year-old child. They're cutting it to an adult through a guardianship, and a judge will decide how the money's used. And when that kid turns 18, they're just going to get all the money. and probably not use it very wisely given their age and lack of experience.
Yep. So I'll be honest, I didn't even know anything about it. I mean, crazy enough, until I met you. 10 years or whatever it's been. I knew nothing about having properties. I mean, I didn't have any investment properties, but oh no, that's not true. I did.
You definitely did.
Yeah. But I didn't even know about probate. I didn't even know what it was, honestly.
My best clients are in their 50s or 60s, and they come in and they say, I just had to do this for my parent up in some other state, and it was horrible, and that attorney got way too much money. And I went on the internet, and just go on the internet, look revocable trusts. You're going to find it, and that's just the answer.
And I was like 40 when I found out. So I know people, and I had no clue. I didn't know anything about it. I didn't, know anything that was going on. So I'm just saying, I know a lot of you out there don't know either. And a lot of you real estate agents that are listening to this, definitely if you're working with investors and things like that, and even, this is good stuff and good information that you personally need to know to be able to help your clients. Can you sell it? Can you sell a home that's in probate?
You can, but you need a court order. So the biggest trouble that we have a lot of the time with realtors is we'll see realtors can sometimes be overprotective of their client, and they're afraid that the attorney is going to ruin it, ruin the deal, or screw it up somehow. When we're talking probate, you have to have that lawyer, and you want to have a lawyer that does it because it can take a very long time to get the orders that you want. What we see a lot is most realtors don't understand, but I'll get a contract, and they'll say, okay, the closing is going to be in 30 days. Look, we have a signed contract. And what the realtor doesn't understand is that, well, the person who signed that contract has no legal authority to sign the contract. Who is the owner of the home? The owner has passed away, so it's naturally going to be their children can sign the contract, right? Not the case. You don't know who's going to be appointed. You don't know who has authority over that home. So we can quickly help a realtor by entering into a quick additional contract for a future interest in the home, and says, listen, we've got to go through this probate process. The other thing that'll freak out the realtor is, it's going to take me how long? How long? I said it's got to be in 30 days. I can tell you that I did accomplish that feat one time, and it was a miracle. And the chances are of a realtor bringing a contract in that for a home that must be probated, that has yet to begin the process, for you to get it in 30 days, it's going to have to be very simple in the sense that we have one child, one beneficiary, one person petitioning the court. We don't have to worry about any other family members or notice to anyone. Then maybe we'll get it done in 30 days.
You've done it. You did it for me one time. I mean, you've done it for me multiple times, but one time in like 90 days, which I thought was awesome because you told me it was going to take like 8 months.
Well, I always give worst case scenarios.
Which is smart.
That's what attorneys are supposed to do. We don't have the best bedside manner because we don't want to be told later, well, how come you didn't tell me this could happen?
Yeah.
So I'll always give you the worst case scenario.
Which has happened, where it's been 8 or 9 months. So if I am selling a home, I have it on the market, it's in probate, and you've started the probate, and I've executed a contract, so I don't know who's signing it or whatever. Is that a binding contract, or can the buyer?
It's a binding contract if the person petitioning for the probate, which is your seller typically, has received what's called letters of administration. That is the order from the court that says this is the person who has authority to handle the affairs of the estate. That person may sign the contract. And realtors out there, do your sellers a favor and say it is Joe Blow as personal representative of the estate. You do not want them on the hook individually. They don't want to be individually liable for this contract falling apart. They are not acting individually. They are acting in their capacity as the personal representative of the estate.
So if I took a listing, because this is good meat. This is really good stuff right here. So if I took a listing and I just put, let's say it was whoever it is on the tax records, right? Whoever shows up on the tax records, and I just put that name, and then a buyer comes in and I have the son sign the contract, that's a mess, right? That's a legal mess.
Absolutely. And if that son says, it's okay, I had a power of attorney for dad, the moment someone dies, their power of attorney is null and void. And guess what? Their death is a very determinable date. You have a death certificate. So do not create a situation and I know a lot of realtors also, you like to have that seller sign a contract with you.
That's right.
That you get to sell the home. So who are you contracting with? Are you even contracting with someone who has the authority to do that? You could be contracting with the son. The sister ends up getting the authority to do it. You're out of luck.
And now you sold it, a buyer signed it, and now nobody's even, this is all a legal mess, and now somebody's coming back to sue you because you did all this mess.
And to really open up a giant problem, what if it's homestead property? Do you even know if there's a minor involved? Because you can't, homestead property is such a special thing, especially in the state of Florida, that it's not just going to be whatever your client decided to file. And then that gets you into the title companies. What does the title company want? Do they want an order of homestead? Do they require an additional order of sale? Some title companies do, and some title companies don't. And the most you can front load your client on what to expect, because guess what? Court order means time. And to a real estate agent, that means, I got to do another addendum for an extension. How long can I keep these people on the hook?
That's right.
And that's what it is. And if you need an order, you're relying on a lawyer, you're relying on him getting in front of a judge, and then you're relying on a judge's calendar. And a judge doesn't share his cases. If he's on vacation, you're waiting.
Yeah, those are really good points. So basically, if you have to eliminate or whatever, the most likelihood of probate is by having a trust set up.
That's the easiest.
Yep.
That is absolutely the easiest. That being said, you can create life estate deeds. If your client shows up and says, look, I'm the remainderman on the deed, mom is dead, here is the death certificate, that's your client.
Yep.
Ladybird deeds, they'll work as well. They're just not the best estate planning tool for that person while they're alive. And the trust is going to work the same way as the life estate deed, in the sense where it'll say, here's the death certificate again. Yeah. And the document says I'm in charge.
So how, as a realtor, how am I going to know that this property, I just had somebody call me up, let's say, and they say, hey, I want you to, or whatever, or look a bunch of realtors up, have them come do listing presentations or whatever it is. And I say, okay, I want you to list my home, Kristen. My mom died. Okay. And as a realtor out there, how are they going to know this is in probate?
They're not going to know it's in probate. You can search the court records. It will be the estate of whatever the name of the owner is. That's how you search it in the court records. But most real estate agents, they're not going to do that. If they want to know if it's in probate, truly the best advice you can give them is, realtors, you have your insurance agent, you have your title company, you have your mortgage person. Get a lawyer. Get a lawyer who's in your corner.
That's what I do.
Who does probate. And say, hey, I got a quick one. We lawyers, we're not expecting the same thing that the insurance and the mortgage, that you guys are expected to do deals back and forth all the time. The attorneys know you might get one, maybe two probates, maybe. And that's if you're doing a lot. Yeah. We're not going to have much expectation. But if you create a good relationship with them, for Kristen to call me up on the phone and say, hey, can you at least just tell me the status of this probate? That'll take me 3 minutes.
We've done it multiple times.
It takes me 3 minutes to answer those questions. Even when it's not my probate, I can figure out the answers pretty quick.
So just give us the steps real quick. So you can't basically go and list a property that has, let's say I'm the one who died, and it says Kristen Stampini is the owner of this property. They can't go and have somebody just list it with my name on it and somebody else just sign it as a listing agreement and sell the property.
They do it all the time. Legally, no, they can't. And they will. And if they can get all the way to the closing, it will be the title company alerting them that day. I'm sorry, you can't close today. We don't have what we need.
Yeah.
You have to go through probate.
Yep, and I've seen it. It's horrible. I've seen it happen to other agents. It's just unbelievable.
And the thing about probate is most people have no idea what it is. So it's it's an easier explanation if you're saying, well, hey, the financing didn't come through. We need another 20 days because just the loan isn't working.
Because it happens and people know about that.
When you have to explain that you were in contract with a piece of property that's owned by a dead person and it's going to require this gigantic court proceeding, that's what most people think of when they think of court, even though it's not. They think, oh my goodness, lawyers, courts, this is way more than I thought I was going to get into. More often than not, you're going to lose your seller.
Okay.
Or your buyer, I mean.
So give me the steps. If I am going and I'm going on a listing agreement, or somebody called me up and said, hey, my mom just died. Can you list her property? Tell me the steps that I need to take.
So if we're going to start at the very beginning, that would be your listing agreement. Your listing agreement should provide for things in there that focus on your relationship with this person and make the assumptions, but in writing, and cover yourself in case this person is not going to be appointed by the court. Because if they're not the ones who are appointed by the court, you're losing your client. So cover that in your listing agreement first. If you know right off the bat that they are going to have to go through probate because they've said mom's dead and she's the owner of the property, you want to get that attorney on board ASAP.
So what happens if I don't know, though?
If you don't know that she's died?
No, I know she's died, but now I don't know if it's going to be in probate or whatever, and I'm going to take the listing. Shouldn't I just not even take it until I talk to somebody? Like an attorney or a title company or somebody that can look that up?
If somebody's walked in the door, the proper thing to say is, give me a moment. And if you have that person on call, we're going to be able to pull the deed very fast. We're going to be able to know who the owner is. We're going to be able to know these things. Make those calls. Don't promise anything like I like to say, pardon my French, don't let your mouth write a check that your butt can't cash. Because if you're going to create a contract with someone that you can't do it with, they're coming to you as a professional.
Right.
They're coming to you for advice. And if you tell them later that you didn't know something, then they're not going to trust you anymore. That's the bottom line. The trust is earned in the very beginning. And a lot of people in my professional experience, not legally, just business, they will respect this answer. This could create an issue. Yep. I'm not entirely sure. Let me get back to you in a timely manner. And most people will respect that.
Absolutely. Because they don't want you to say something and act like you know it and then go find out later and you were wrong. Mm-hmm. They would much rather you say, you know what, I'm not sure. Let me check it out.
The big one that we get all the time is every now and then a judge will make the person applying to the court post a bond. And I've only had it happen 2 or 3 times. But those 2 or 3 times I was really happy that I told the person, you might have to post a bond.
Yeah, absolutely.
Because if I didn't tell them, they're going to say, why didn't you tell me I had to do that?
Yeah. And you know what? Where you find this is if you have gone under contract and all this other stuff, gotten your listing agreement and everything else, you find out, just like you said, it's from the title company. Because the title company is not going to insure this and not going to close on it with and not going through probate. So I've seen it, you guys, so many times. If you're selling a lot of real estate, this is especially in Florida where people are a little bit older. I'm telling you, it happens all the time. So this is so.
You didn't almost say they're dropping like flies. You didn't say that.
Okay, so how can our listeners reach out to you? Refer you to the clients, find out more information. How can they do that?
Our website is Eastham. It's spelled East like the direction, Ham like the food, Law Offices, it's plural.com. Our email is emjeastham@easthamlawoffices.com. And our phone number is 561-395-6800. Again, it's 561-395-6800. Just pick up the phone, give a call, mention that you heard it on the stamp of approval, and that's all you're going to have to do. You're not going to get a bill in the mail from me if you just got a question or two.
Wow. Thank you so much, listeners. Thank you, Erik. Have a great day, everybody.
Thank you.